Well, hello, everyone. Let's get started. I'm Bill Treanor, and this is our fourth class of Lawyers as Leaders. And I'm just delighted you're joining us, and I'm delighted that we have as our guest speaker today, Professor Victoria Nourse. So welcome, Professor Nourse.
Thank you. Thank you for having me.
So a few words before we launch into the discussion. I want to thank you. The questions that were submitted this week were absolutely terrific. And I want to recognize our TA for the week. We have, as you know, we have one or more TAs every week to help assemble all the questions. So Tyler Kuhn was the TA for this week, and he did a terrific job. And I also want to thank again Dean Sale, who helps me think through these sessions. So thank you, Dean Sale. One thing that a number of people have asked is why the questions are due Thursday evening, which is early. But the reason why we have them in early is that the TAs then draw on them, and actually they provide essentially the backbone for the questions. So we need a couple of days to take the questions and then have the TA do the format. So that's why they're early. And again, they were terrific this week once again. And if you have questions during the session, send them in, and then to the extent possible, I use them during our Q&A. So enough with the logistics, and now to move on to our conversation with Professor Nourse. And this is obviously, it's a very busy time for you. So you're going to be on PBS tomorrow for the Judge Barrett. You're going to be doing the play-by-play.
Yep.
And and I also have to just acknowledge, I think you've got a very good background.
I was very excited by my room rater. 8 out of 10.
How'd you do?
8 out of 10. Not bad.
Excellent. That's excellent. So any tips for the future, things you'll be focusing on, or are you going to stay with the 8?
I'm going to stay with the 8. They asked me they suggested I get a plant, but I have black thumb. So I think it would not really add to have a dead plant.
Very good. Well, I think that's a very wise focus. So, we're very grateful that at a time that's so busy for you, that you're taking the time to chat. And we're going to be talking about a number of things. You gave us 2 readings. One a podcast from NPR that focused on your work drafting Vawa, and the history of Vawa after you drafted it, and why it was so important. And then we also have really a superb article from the Stanford Law Review that is really your constitutional philosophy. So we're going to be talking about both of those, and also the interconnected dimension of it. One of the things that we're trying to do in this course is we're bringing faculty members who are both great scholars, and who are also very much involved with trying to make change in the world. And that's very much been a hallmark of your career. So you just a few words about your biography. So you were a Stanford undergraduate, graduated Phi Beta Kappa. You went to Berkeley for law school. And as you talked about in your podcast, you paid your way through law school by waiting tables to earn money. You then clerked for the famous Judge Weinfeld on the Eastern District of New York, worked for Paul Weiss, and then began career in public service, first working for the Iran-Contra Senate Committee under Warren Rudman and Daniel Inouye. You then worked for Senator Biden, and while working for him, drafted, after I guess a brief stint at the Department of Justice as an appellate lawyer, you went to work in the Senate and worked for Senator Biden, and drafted Vawa. And that has been, the story of your work was recounted in the 2009 book, Equal Women, Reshape American Law by Fred Streiba. You were nominated in 2010 for the 8th Circuit Court of Appeals, and ultimately withdrew your nomination because the Senate Judiciary Committee would not provide you a hearing. You've been with us since 2010,
Mhm.
And you were chief counsel to Vice President Biden from 2014 to 2015.
Mhm.
So really a remarkable career, uh, you know, very much working for the vice president, working on the Senate, incredibly impactful. And you're also a remarkable scholar, and I just, the work that you've done, particularly in constitutional theory and legislative history, has been you're so influential and so important. One of your early books was about Skinner versus Oklahoma, and you wrote In Reckless Hands, the story of Skinner versus Oklahoma. And then in 2016, you wrote really an amazing book, Misreading Law, Misreading Democracy, which was published by Harvard University Press. So you're really somebody who combines both very impactful public service with a leading role as an academic. So one of the things we'll be talking about is kind of the connection between the two. Um, so let's start out. Did you always want to be a lawyer?
No, I wanted to be a historian like you, Bill. um, actually, my mother, when she was alive, told a story. I have no idea where this came from. It's a little bit embarrassing, but somewhere between fifth and eighth grade, there was a play about Dred Scott. And I volunteered to be Dred Scott's lawyer.
Oh my gosh.
So, and I grew up in a pretty plain vanilla kind of place. So it was a little bit striking, I think, to my mother. But I was trying to decide at the end of my time at Stanford. I went out there to be an engineer, actually. I was very good at science in high school. And my grandfather was an engineer, and I idealized him. He grew up poor on a farm in Massachusetts, and he got a baseball scholarship to Brown. And this was around the turn of the 20th century. So my dad was old when he had me, and he was old when he had my dad. So this goes way back. So Brown was a low-class school at the time. And my grandfather managed to strike out all the Harvard batters. And he was on the front page of the Boston Globe. And he got, he played for the Red Sox for about 30 seconds, didn't do so well, and got farmed out to the Sacramento League at the time. But I just thought he was a brilliant guy because he moved from there. He actually refrigerated all the milk plants in New England, the Hood milk plants. And he built himself up from nothing. So I really idealized him. And so I went out to Stanford to be an engineer, but that didn't work out so well for me. There were many reasons why I quit engineering, but in part it was because I loved history. Mm-hmm. And then I tried to decide, well, should I go to law school? Should I not? And I just did it kind of on a whim. And I went up to Berkeley, and then the first semester I fell in love. So
now were you, you talked about playing Dred Scott's lawyer.
That's a pretty auspicious start, somewhere.
Clearly.
Yeah. I had to start really, with a tough case.
So was your family supportive of you becoming a lawyer?
Not particularly. Around the dinner table, my sisters are about 8 and 10 years older than I am. I am what my mother calls the happy accident. And, but in that time, lots of things happened, like the women's revolution. And so what happened was that I would hear them say very negative things about women who went to law school at the dinner table. That it was kind of uppity, and what were they doing that, and all that kind of stuff. And that terrified me, actually. I actually ran away from home to go to Stanford. They really wanted me to stay on the East Coast. So very old line East Coast family. My mother's Norwegian, but my father's very old line. So I ran away and kind of never looked back. It was not a happy thing. I basically had to separate from my family quite a bit to do what I wanted to do. And they were always proud of me, and we reconciled. But yeah, I'm the only person I know who rebelled by going to law school.
I think that's right. You are unique.
Yeah.
And then you supported yourself through law school by working?
Yeah, and well, at first I had to become a California resident to afford it. So I took a couple years off between college and law school. And at the day I worked for an economic think tank because I was pretty good at math. So I did that in the day, and at night I was a waitress at a very fine establishment, no longer there, Cafe Merceau, where I learned a lot about French and California wine. And I built up a nest egg, basically. And then I got loans and worked simultaneously, both at law firms and other jobs to keep myself going in San Francisco. I lived in San Francisco and I actually went across the bay every day in my tiny little Honda,
Wow.
which would weave across with the wind. But, you know, you do what you have to do. I didn't know if I'd want to do it. My backup was to go to, there's a particular program at Stanford involving history and Americanist theory, essentially, and that was my backup. But I happened to fall in love with law school, so there you have it.
And what did you
Also
like?
rare that people fall in love with law school. So.
And what did you like about law school?
It was a combination of what I loved about history and about engineering. So it was, it's abstract. It requires rigor as an engineering, but it's also about human beings, not bridges. You know, it's about human problems and trying to solve human problems. So it was a great marriage. It's also difficult. You know, I think I really didn't study. I mean, it sounds a little cocky, but I didn't study that hard in college. I really had to work hard at law school. My year, Dan Cohen was my first year criminal law professor. And he's a very, very smart man, as you know. He's quite an academic. And he was teaching us an article he wrote in the Harvard Law Review at the time about called acoustic separation, and which I'm sure you've heard of, but it's very abstract. And I tell my students the story. We had pencil grades after the first semester, and then you have a chance to redeem yourself in the second semester for a year-long course. So I had all year-long courses, and then I had criminal law. And what was odd was I got passes. They only had honors, high honors, and pass for all my classes in the pencil grades in the first semester, but I was number one in my Cohen's class, which suggested to me that I needed to learn how to study better. I had freaked out at the exams. So his was the only one I had like 48 hours to take, right? So I had time and I was panicking on the exam. And I really didn't know how to study well. I had memorized all of the civil procedure cases for my civil procedure exam, but that's not how you move from the rule to the facts. You need to know the rules and the facts, but you need to bring them to a new situation. So it's like a problem set in that way, but I hadn't really studied. I studied more for a history exam, so I memorized all the cases. So I can still talk about international shoe and Hansen versus Hansen and all that kind of stuff, which, you know, not useful. It's useful to move from the rule to the new set of facts. And so I started to take exams. I would go into the library and I would take exams. And I teach my students this now. It's really a great thing for them to see someone who did not actually, even though she loved it and did really, really well in the hardest class, maybe didn't do so well in the other classes. So had to teach herself how to take the test. Because many students come from STEM backgrounds. You know, it's not quite the same thing to take a law school exam. You have to be able to use words like reasonableness to sort of paper over the edges when the formula doesn't quite come out. You need to learn how to move, how to apply a difficult concept and what you will say if that difficult concept, such as causation, comes up on the exam. So I taught myself how to do it. And I bring that to the classroom now, and I think it's pretty cool. I think the students like that story.
Yeah, I think that's a great story, you know, because I think, you know, one of the things that a lot of students have is the sense that the people who do well in law school, that it's just innate.
Mm-hmm.
To be able to say that, you know, the difficult, I mean, for some people, for whatever reason,
Right.
it's innate, but that's just, you know, a small percentage. And I think others kind of thinking through, you know, what exams you're looking for and how you prepare. I mean, that's a great, you know, you're a great example of learning about how to take exams and do well in law school.
Well, it also there's too much pressure on the first semester for students who, you know, I had a lot of social anxiety at the time. I was very shy. And you're in graduate school and, you know, that's a new environment. We put so much pressure on the first semester. And I've seen so many stories at Georgetown too of people who have had issues, whether in a family, you know, you can't predict when someone's going to get sick or your mother's going to have to go to the hospital, and students shouldn't feel like their career is over after the first semester. I mean, I've spent a lot of time trying to disabuse students of that fallacy, because a lot of people, I mean, I'm sure you knew this from your own law school career, some people who did great out of the box don't end up being great lawyers because they kind of hit their peak and then they don't work hard, and you have to work. You can't just skate over, no matter how smart you are. So, you know, if I had to change one thing, I think the clerkships now have gone back to this first year race, and I don't like that. I think the first year is only part of your career in law school, and we really should focus on at least 2 years of experience before people, you know, get these great clerkships. But, you know, that's just my view.
Yeah, no, I mean, I think that's something that, you know, I've definitely pushed for, because I think, you know, the first semester is really, in some sense, it's not a very good predictor. You know, some people come in with a preparation that equips them to do very well in law school exams, but that really doesn't mean that much long term.
Right.
You know, and I think, you know, another thing that we've talked about, which I think is very important, is that, you know, that there are bumps along the way. And people just have to realize that, you know, nobody has kind of a straight path in life in which everything's a success.
Well, yeah, I mean, I've had some big disappointments in my career, some public disappointments. I was not confirmed to the Seventh Circuit. I did not get a hearing. And early on in my career, I was one of 4 for the final place for Justice Blackmun's Supreme Court clerkship. So I interviewed with him, and I did not get that clerkship. And I remember what's interesting is that was so much more devastating for me than losing the opportunity to be a judge. Even though the judgeship was much more public, you know, it was in the press, and it was a great honor, an extraordinary honor to be nominated by a constitutionalist himself, President Obama. But, you know, I think students really need to know that one of the things that happens in your career is that there are bumps, and oftentimes those bumps end up leading you to a better place than you think at the time. And when I was young, you know, that loss of the clerkship really had me depressed for about 6 months. It was where am I going to go? What am I going to do? I thought Weinfeld was one of the only judges, on a trial court judge, who was a Supreme Court feeder. I could try again. What should I do? Why didn't I go to Yale? So, you know, those kinds of things. And the reason I didn't get the clerkship is I didn't say anything. Here's an interesting story. All he said to me was, he didn't ask me any legal questions. I was prepared for very complex legal questions. And he kept talking to me about the abortion decisions and about how he was threatened all the time. So people would send him threats. And I basically was so shocked, I was kind of naive at the time, shocked, you know, that I barely said a word. And I think, you know, that wouldn't be me today, but it took me a long time to overcome that. So that was part of a syndrome where I wasn't sufficiently confident, I think. But I really took it out of myself. And now later in life, you know, as I said, I lost the judgeship. And for many people, that would be the pinnacle of their career. But for me, I'd already realized, you know, when I lost the Supreme Court clerkship, guess what? A guy named Arthur Lyman, who was the Senate counsel, turned to find somebody to bring to Washington to work on Iran Contra. And that was when they had ABC, NBC, and CBS. There were no cable networks, really. And I became a minor celebrity in Washington. I was out at dinner, and I was with Charles Freed, who became the Solicitor General at the time. I was with another law professor, and Charles Freed, and people kept coming up to me and asking for my autograph. So it was very embarrassing because I was a law student, and here I'm still shy. I mean, it's only like a year later, and I'm saying, "Oh, this is the Solicitor General of the United States. Isn't that, you know, so great?" And it's just because my face was right behind the lawyer asking the questions, and I was on 24 hours a day for about 7 days. So my failure on one side led to this other opportunity, which I probably would not have had hadn't I not worked at Paul Weiss during the period of that clerkship. And of course, even though I did not get the judgeship, I was not confirmed. I did then get a call from a certain vice president who asked me to be his chief counsel. And I have to say, it was under very difficult circumstances I could not tell you or even my family about his own son. So I was delighted to be able to do that service and very honored by it. And I could not have done that if I had been a judge. Now, not everybody's career works out. Like there's not, a plus and a minus side. But I think the overarching arc you see when you're older is so much different than when you're younger. And the thing I'd like to emphasize for students is that when you're younger, each particular seeming failure, whether it's a B, as some of my students have, or something bigger, I don't get the job in big law. I don't get the job in big law that I really want. I don't get the clerkship I want. Really, the point is to put it back in the game. I was lucky enough to get opportunities to let myself put it back in the game, do wonderful things, and you will be too. Life is much longer than you perceive it when you're 21 or 25, and it's your first big disappointment. It's how you get up, really, that is the most important thing. And there will be failures. We all have them. And it's how we manage them, I think, that makes us who we are. So that's my advice to students.
Yeah, I mean, I think that's great advice. I mean, particularly at this very difficult time, where we're, there's so much kind of stress and anxiety, for very good reason.
Right.
Right. But I think, emphasizing, the importance of resilience is just such a powerful lesson. And I mean, I think, I look at that. I mean, your point that, for some people who do beautifully on first year law school exams, that's like the high point of their career.
Yeah.
Right? But it's the people who are resilient and who bounce back and move forward. That's so important, and it can't be understated.
Yeah, I can't emphasize that enough as a teacher, which is that I will spend lots of time talking to students who want to know what they did wrong on the exam. And I'll spend any amount of time on that because they are coming to me to learn how to fix a problem. I was too shy to even do that when I was in law school, but I think that is what we're here for. That's what they pay us the not big bucks for, Bill. To sit there and say, let me tell you my story and how I taught myself. And here's some other options. I also give them some other options I've learned from other folks. Not everyone likes to take exams in advance of exams, which is my solution, but there are other things that they can learn to do. So I do think that that's really important, and I admire the students who do that. They don't sit in silence and go, oh, woe is me, I'll never be a great lawyer. Or they find other things. I remember talking to a young woman and she really wanted to go to Williams and Connolly. Well, her grades weren't at the top of her class. But then she involved herself in student government and did a whole bunch of other things where she was a real leader and an organizer, and that's a different kind of skill. And she's got a terrific job going out of law school. So it's trying to learn what you're good at and what you're not good at, and that can take some time too. It took me a long time not to be shy too.
So let's go back, talking about your career. So, but I think those are, that's such a powerful, important message, because, again, everybody has bumps on the way. And, the resilient, I mean, forgiving yourself and not dwelling on it, and the resilience is just absolutely crucial.
It really is.
So how did you wind up at Paul Weiss? So you clerked for Judge Weinfeld.
Well, most people don't remember who Weinfeld is, but I tell my students now, have you ever heard of a firm called Wachtell Lipton? Well, Marty Lipton was one of his first clerks. So he was legendary in New York for actually graduating top flight New York lawyers. And so I had been I went to Steptoe one summer. I went to another New York firm, kind of more of a white shoe firm, as they call them, Simpson Thatcher one summer. But I interviewed at Paul Weiss, and I just got this feeling that you know, we all knew that we were going to look a little bit odd. Like the whole class would be evenly divided. So the class of associates would be half women and half men, but there were no women partners. There was one woman partner at Paul Weiss in litigation when I went there. Hmm. And so, but we were just happy to be there, right? We're in the mix. But I got this feeling that if you were blue and you did the work, it wouldn't matter. I got this feeling they were tough and they really respected Weinfeld. One of the named persons, Judge Rifkind of Paul Weiss, ending in Rifkind, is a judge. And so he basically convinced me to go to Paul Weiss, that I would be treated fairly. And so I went to Paul Weiss and I worked on a variety of matters. I wasn't there for all that long. One of them was, I moved to the tax department. People don't realize that I was actually a tax lawyer for about 30 seconds. Because there was a better ratio of partners. There were 3 women partners in the tax department, and they were also the smartest people. And so there's a current tax professor out at Stanford who's brilliant. And I, when she was an associate there, I translated her to the entertainment litigators, who were very charming and very, you know, loved Hollywood and all that kind of stuff. They represented all the Hollywood movie studios. And they did it in a big tax litigation where I was, and I was the associate on that big tax litigation. So I had to translate this arcane tax law to the entertainment lawyers. And it was before Judge Kozinski. And I wrote a memo once he was named to the Ninth Circuit, getting him off the case based on some claim about, you know, judicial structure. I don't even remember what I was arguing, but he got off the case. It was a very interesting, he had a very interesting relationship with a woman partner who was litigating it from the tax department. My only claim to fame there was the only complaint I've ever written in any real lawsuit, because I was an appellate lawyer at Justice, was for $3 billion against ABC, NBC, and CBS. And at that time, that was a lot of money. So it was under civil RICO in California law. But if you're going to file one complaint in your career, it might as well be for $3 billion against
absolutely
television studios.
And so then how did you wind up going to the Iran Contra investigation?
Well, I worked really well on that case. I you know, I was kind of a workaholic at the time. I was happy to be there, and there was a partner in the entertainment department who sort of took me under his wing, and then another partner, Jay Topkis, who's pretty well known as a First Amendment lawyer, had me work on a case involving the religion clauses in the Supreme Court, which was a plum. And you know, Larry Kramer, who was once the dean of Stanford, was clerking for Judge Friendly when I was clerking for Weinfeld, and he taught me to read things backwards to avoid typos. And that's what I did for Jay Topkis. So there were no typos in my brief, and I had to put a little asterisk. I had still not been, I had taken the bar, but I wasn't a member of the bar yet. So I had to put a little asterisk by my name saying I was not yet a member of the bar. But I did well in these assignments. And so Arthur said one day, he woke me up at 8 a.m. on a Sunday and said, would you like to come to Washington? And what am I supposed to say? He's the head of the firm. And he's a legend in New York at this time because he did all this stuff involving riots. Now people only know him because his son writes the Bourne movies. The other son's a judge. So he was a really wonderful, decent man. He was really humble, a brilliant litigator. So what was I supposed to say? I said, yes, I'm going to Washington. So, I mean, I was there, you know, since then. I mean, 2 days later, when it was announced at the firm, there was a senior associate who came into my room and started screaming at me, saying, you know nothing about foreign policy. You know nothing. And I said, well, yeah, I'm not really going down to do foreign policy. I think I'm going down to be an associate for about 12 lawyers appointed by these senators, which is what I was. And I'm going down because I'm a workaholic. I billed a ridiculous number of hours that first year, in part because I was flying back and forth to California, and I would double bill, actually. Not illegal, but not something I would recommend. But I would, because of the time change, I could work on the plane and work back, you know? So anyway, needless to say, I billed a ridiculous number of hours. They were taking me down because I could handle this, they thought, right? So, and he needed a woman. The blunt line is he needed a woman. Why? Well, here's the story. Ollie North, who was the subject of the investigation, was alleged to have taken various documents out of the White House. He also alleged to have passed cash in the White House. And he had an assistant named Fawn Hall, and Fawn Hall was a major figure in the investigation as well. And Fawn Hall was alleged to have taken documents out of the White House. And Howell Heflin, who was a senator, a former judge from Alabama, said to the media, "I think she took those documents out in her bra." Now, thinking about that, that seems a little strange. She claims she took them out in her boots. But he was alleged to be sexist. He was on the committee because of this remark at the time. And so they were very concerned that there be women on the committee. Now, there were no women senators, right? And there were no women lawyers either at this time. So Arthur decided to bring a woman to sit behind him. And then the lawyers from Williams and Connolly, who represented Ollie, did the same thing. So there was a very young woman counterpart. And it was the visual, that they wanted. I knew that. And I suppose I could have felt bad about myself for that, but I just thought, well, I'm so happy to be in the room. Young women ask me this because, I don't think my sisters would have had the same opportunity. And so I just was happy to be in the room, and, people treated me very well. So I really had nothing to complain about at that point.
So, and actually just to loop back, because I think our students may not remember, but
yes, I'm sure I've skipped over things.
What was Iran-Contra about?
Well, the dean also worked on a different part of Iran-Contra, just so you all know. Had we met at that time, we would have had to be in separate rooms.
True.
So, because he worked on the independent counsel investigation. There were two investigations, and the allegations were that Ollie North was running foreign policy from the White House, and that the main gravamen for us was that he had actually profited off of this and had Swiss bank accounts. And so, and there were various other allegations about taking money that was due to Iran and giving it to freedom fighters in Latin America. So subverting foreign policy in a way that actually benefited individuals within the White House. And one problem with this was, of course, it was contrary to what Congress wanted. Okay, so Congress said, no, you can't give money to the freedom fighters. And so they got around this by sort of circumlocution by taking money from Iran and giving it to the freedom fighters. That was a constitutional problem. And we had a constitutional advisor. Philip Bobbitt was the constitutional advisor. At the time, he's a well-known professor at Columbia and Texas. And but there were also allegations of criminal behavior, which is ultimately the dean went to work on the independent counsel and their attempt to determine whether any crimes had been committed. And the easiest way to explain that is that there was an account in various Swiss bank accounts that Ollie North had, where it appeared that he was profiting personally from all of these off the books foreign policy adventures, to put it, I guess. Does that explain it, Bill?
No, it is. And North testified with a grant of immunity. And so when I worked on the prosecution, we were shielded. So with a big, we weren't allowed to find out what he testified about. So and we had all kinds of safeguards. But actually during his trial, one thing that was very striking was, that there would be various things that he would say. And we were like, what? And, the press would be completely uninterested. And then we realized it's because he must have testified about this, but we had no idea.
That must have been strange.
That was very strange. But that's, but again, this is an example of kind of your work were you the only woman attorney on the staff?
No, there was a staff director who was a woman, a prominent staff director. Staff directors of a top position in the committee hierarchy in Congress, who actually ran the committee. And I can't quite remember, there might've been one, the senators named their own lawyers. Okay, so each senator on the committee had their own lawyers. And I think most of them were men. There was another woman we brought down from Paul Weiss to help me because it got to be such a burden because these lawyers didn't have any associates with them. They were just named the lawyer. So they left their private practices and they came from the states where the senators were from. So George Mitchell had a staffer there and from Maine, et cetera. But it's not something I really, what was the biggest difference there was age. These were senior lawyers and I was like the just the baby, you know. And so that was the real thing. But Arthur treated me incredibly well. He set the tone, and this is something important to leadership. He set the tone. So I was in all the meetings. So there's a famous meeting where we have to decide whether to take Ollie North to court, right, over immunity and some other things. And he doesn't want to because he wants to get back to Paul Weiss because the firm, was near and dear to his heart. And he wanted the investigation to end. And so we have to have a vote as to whether to take Ollie North to court. And the only people who vote for taking Ollie North to court are Philip Bobbitt and me. But I was standing there. I still remember that vote because there was a lot of speculation afterwards of what if we had taken him to court. The hearings might have turned out differently for those students who don't remember this. The idea was he would not give us a deposition. So we didn't know. So Arthur went in blind, and Arthur was a brilliant lawyer, but going in blind was a mistake, in my opinion. And mostly because Arthur, and this will tell you something about the difference between Washington and New York practice, which is, he's a prosecutor, defense counsel. He negotiated riots at Attica. He had Carl Icahn sleeping on his couch, so he went from the super rich to the, super unpopular, but he did everything as a lawyer. And, why didn't he do so well? Well, here's the reason. He was on television. And if you're in politics, you know a little bit about media and how important media is and how you appear. Ever since Nixon sweated during his debate with Kennedy, politicians have understood that how they appear on TV is very important. And when they did split screens of Arthur and Ollie North, so on one side of the screen is Arthur Lyman and on the other side is Ollie North. Ollie North looked the part of the tried and true Marine, and very handsome and very, more than straight up. And Arthur looks like a somewhat disheveled, he was always disheveled. That was part of his charm. Disheveled lawyer. And part of it was because he was Jewish. In a way wanted someone who was Jewish for a variety of reasons. But we also got a lot of anti-Jewish hate mail. But Arthur really didn't understand the media, and he didn't understand what I call the Electoral Connection, which is David Mayhew's famous political science work, that if you want to understand what's going on with a senator, let's say Senator Joni Ernst right now, what's going on in Iowa right now? An election, right? You got to think about that first. That might not be what they end up doing. They often go against apparent interest. But think about those incentives first if you want to understand politicians. Also think about, Joe Biden taught me, think about what they're doing at the kitchen table in Iowa or in Kansas. And I lived in Wisconsin for many years, so I had lots of Wisconsin students. So I think about, well, how would they think about that in Wisconsin? I wouldn't ask what the New York Times thought, and I wouldn't ask what the Washington Post thought. I would say, well, how are they going to think about this in Nebraska or somewhere like that? And Arthur was not asking those kind of questions. He was trying to outsmart North in cross-examination that would have been brilliant in a courtroom, but it wasn't brilliant on TV. And he came off looking mean and kind of unpatriotic, and Ollie North came off looking very patriotic. Mm-hmm. Unfortunately, and I would mention this as well, most people don't know what was going on behind the scenes. Behind the scenes, during the middle of that interrogation of North, we went back to the cloakroom, which is the room behind the committee hearing that you see on TV. And there was a bomb threat against the law firm in New York. And then this is before 9/11, so there's no security in the Senate. And then there's a death threat against Arthur Lyman. And he asks us, and he looks us all in the eye, if you want to leave, you can leave now. You do not, because I was sitting right behind him, right? Oh my God. And of course, what are we going to say? No, we're not going to leave now, right? But it was terrifying in some ways. I joke about how I dove to the floor faster when he'd ask me for a document because I had all the documents memorized because he'd have to hold it up and do all sorts of things about it. Behind the scenes, these things are so very different than they appear on the surface, which is why people should be cautious about coming to conclusions about things that are happening real time on TV, in my view. It's easy to make mistakes. The mistakes you make often are based on your assumptions about how the institution works that may not be actually true. So Anyway, I learned a lot about, I loved Arthur. Arthur was terrific to me. And he wanted me to run the Michael Milken project or litigation when I went back. And I said, I'll be inundated with documents and discovery. So I think I'll go over the Justice Department. I thought that was strange because it was the Reagan Bush Justice Department. Niece was the Attorney General at the time. So.
But I mean, but it's interesting. I mean, you're such an extraordinary scholar of legislation. Does your experience having worked on the Hill, does that shape you as a scholar?
Absolutely. So I'm one of, according to Dakota Rudisil, who's a professor out at Ohio State, who once was running our clinic on legislation, he did a study and he found that 2% of all law professors have had any experience in a state or federal legislature. So I'm one of those 2%. And it has completely shaped my intuitions about legislation and about how legislation gets made and about the process. So I read the congressional record very differently than most other people do. And that has, made me look at the product of that body in a very different way than others. I originally didn't start out doing this because I thought it would sort of be cheating in some way. So I didn't start out working on statutory interpretation, but I was at Wisconsin with a woman named Jane Schachter, who now teaches at Stanford. And she was teaching statutory interpretation. And I was teaching criminal law. And we would talk about this, and I would have such different intuitions. And I once took her, we did a study on this, and I took her to meet these counsels and all of that. And she couldn't quite believe some of the stories coming out of them and who they were. And, when you ask them about canons, which students know, law students know to be about statutory interpretation, members of Congress think C-A-N-N-O-N, as in boom, boom canon, not canon with one N, statutory interpretation. So we asked them, members of the Judiciary Committee, what they thought. And the only person who knew about a canon was Lee Otis, because she was working for the Senate at the time, and she's one of the founders of the Federalist Society. Mm-hmm. Not surprising that she would know. But through talking to her, I realized my intuitions were incredibly different. And although at the beginning of my career, I didn't want to write about that, I had been working a lot on violence against women, and I found out that there was lots of problems in the criminal law dealing with women. I spent a lot of time working on that in my early career. I ultimately decided that this was a benefit after talking to her about my insights, and that my intuitions were so different because of experience, and experience is so valuable in this. One of the reasons that they asked me to do the impeachment hearing was because on PBS is because I understand the Senate a little bit. And the Senate doesn't have a lot of rules like written down. It's full of norms and conventions, I guess you'd say. And so if you've been there, you have to know the rules because you can't figure out whether you have to file an amendment in 24 hours. Sometimes you do have to act very speedily in Congress. People don't understand that either. But I think that experience is both, it makes my work distinct. It also provides a different perspective because students learn about statutory interpretation through the courts. And it used to be that judges were often senators. On the FDR's court, there were many, Sherman Minton, Hugo Black, distinguished justices. They're no longer. We have more of a professionalized judiciary right now. And so, so I get calls like from the Senate parliamentarian who says, how could the Chief Justice get it wrong about how the ACA was passed, the healthcare law? And I'm like, well, he probably never had it in law school. He said, well, there you go. So I think it's been tremendous. And I only regret that I didn't start out doing it earlier, but there you go.
And do you think you look at legislative history different than the courts because of your experience working on the Hill? Absolutely.
I mean, I've talked about this for years, trying to get more people to actually teach the clerks, the Supreme Court clerks, about how you actually read the congressional record. And here's the analogy I make in my book, the Harvard book. It's that if you had to read a trial transcript, any trial, could be tort, it could be criminal, if you don't know that there are rules of evidence, for example, right? If you don't know that there's a process, that there's a jury selection, jury verdict, etc., you might not actually understand what you're reading. So if you don't know the process, you can really turn X into not X. And this is what I showed in the book, essentially, that members or judges would pick on something like, oh, here's a statement. So they read the congressional record like a brief. or a judicial opinion. So they'll pull out a nice statement and then quote it. But you're actually working toward a text. And here's, I agree with Justice Scalia. I'm also, his book was reading law, mine was misreading law. So you might get a sense of where I am on Justice Scalia's version of this. But, I have experience to back that up. It gives me a lot of confidence that I can say, look, if you're going to look at my world, at least look at the rules that govern that world, right? You're into rules, so let's look at those rules. They do have rules. The Constitution gives them power to set their own rules. But so here's an example of how not X can be turned into X, which is to say that you can read the congressional record in a way that would turn out to be exactly contrary to what Congress wanted. So this is the most extreme example, but Judge Mikva, who was both a great judge and a member of the House of Representatives, used this example. He said, well, when I was in the House, I said civil RICO would be misused and it would be used against corporations. And guess what? In the Supreme Court, they used that to conclude that it did apply to corporations. So they used those who opposed the bill, right, to interpret the bill. In a very famous discrimination case, Weber, in a Yale Law Journal article, I showed that Chief Justice Rehnquist, later, used this to misunderstand the Civil Rights Act. He used the opponents, not the proponents. Now, both can engage in what economists call cheap talk, which is they can both exaggerate, and you have to be careful about that. But this is why you shouldn't be pulling any, and where I would agree with some of Justice Scalia's colleagues, that you really shouldn't be picking one or two people out of the record and trying to figure out from that one statement. You can't read it like a brief. You have to find out what were the consensus positions. Bipartisan legislative history, according to members of Congress and most everybody else who uses it, is the best. But that means you have to read it you have to read it from the perspective of people who are authoring the bill. You have to read it as it's moving toward the text. So I have a very different view of it, and I call it legislative evidence, not history, because if you really want to do the history of an act, it's so complicated. You're a historian, unlikely to get a really true, complete history of something like the 1994 crime bill, big bill like that, or the ACA. So you try to look at the record by focusing on the text and then working backwards. I call it reverse engineering. Engineering is a theme here. My grandfather said reverse engineering the text. How did it come to be the text? Because they do care about text, actually. They know that's what the courts start with and have always started with. What's new now is not textualism as a term, but that they end with the text. They won't look beyond the text to Congress's evidence of meaning, even if it's bipartisan. So, when they threw out legislative history, I think they threw out the baby with the bathwater. And I think there can be cases that are resolved by bipartisan history. And in a new piece that Bill Eskridge and I have written a piece called Gerrymandering the Text, where we've argued that Scalia himself gerrymanders the text to achieve a certain result. And that this is a problem with constitutional interpretation as well as with statutory interpretation. So.
I've wondered, so Scalia's background, he was the Assistant Attorney General in the Office of Legal Counsel.
Mm-hmm.
I think sometimes the executive branch, when legislative history was more important, when they wanted a reading of the text, they would get somebody to say, this means X.
Really?
And I think that probably probably underlies part of his focus on textualism.
That's fascinating. I didn't know that. And I do think there are lots of people who think that, lots of lawyers in town think they draft legislation. Everybody drafts legislation, like the president drafts it. Everybody says they draft it. And they get money for people to put things in the record. That stuff is irrelevant. I mean, if it's not written by a senator, it's not privileged in any way as an official statement. And if you're a staffer, you would never just take something like that and put it in the record unless you thought it was somehow immune from attack. I mean, once Oprah Winfrey wrote a child abuse bill, well, it wasn't her, it was her lawyer who was the former governor of Illinois, and she handed it to us, and we were like, okay, well, I don't think anyone's going to go against Oprah, but I'll review it for legal quality, but I think the former governor probably knows what he's doing. So, yeah.
So let's shift now to your work as a drafter, and let's talk about the Violence Against Women Act. So, the NPR podcast talks about that, but let's go back. So how did you come to be really the drafter of this important piece of legislation, critically important?
Well, again, I happen to be the one woman sitting there. But, you know, you make your luck as well as find it. And so the 1994 crime bill is much misunderstood, in my opinion, because I was also in charge of certain parts of that, including the Brady bill, the assault weapons ban. But at the time, we were trying to make lemonade out of lemons. So no one really wanted to do Bill Clinton's bidding to do the crime bill, but Joe volunteered. And so what it was really playing a lot of defense. So Republicans wanted to get rid of Miranda and the exclusionary rule. These are things people don't remember about this debate. Laws are not only about what's in it, but what you get out of it. Okay. So there were huge debates. I was hired to be an expert on all the associated constitutional issues by a guy named Ron Klain. And so I worked on fighting the exclusionary rule stuff, the Miranda stuff, and we won. So those things were out. But I happened to be the only woman sitting in the room because there were a lot of guys on the crime team. And I was the woman sitting in the room when Joe Biden said, we need to do something on women. We really need to. And here's the fascinating part. He was inspired, and so was Ron, by one of our colleagues, Dean, Lisa Heinzerling, who is a tremendous, brilliant expert on administrative law. And she had written this op-ed in the LA Times. And she had said, so rape is not hatred, something like that. That's the title. And she was talking about the Montreal Murders. This was a case where a man went into an engineering classroom. He separated out the women and the men. He told the men to go away. And then he said, you blanking feminists, you can fill in the blank. And then he shot all the women. And it was a shocking event of the day. And so that was the sort of tee off for her questions about the then existing Hate Crimes Act, which was something separate. It actually counted the number of hate crimes in the country. And she was arguing rape should be on the list. At the time, that was very controversial. But it inevitably spurred Biden and Klain to decide there had to be something on women in the crime bill. And that it served a couple of purposes. One, they thought, well, you know, we can right some wrongs here if there are wrongs. And I was supposed to find if there were wrongs, right? And initially, I don't think they thought it was going to be a big deal. But after I came back with my proposal, and I came back with my proposal basically because I was naive. I mean, I think if I was more cynical, I never would have come back with such a grandiose idea. But I did, and I cleared it with Ron, and Ron was very close to the senator, so I thought it was okay. And so then we took the memo to him, and it was just, when you start legislation, you don't draft it, you don't put in the words. What you do is you give concepts, right? And so we had a list of concepts, and this is May of 1990, and he said no to some things, and he said yes to this. And the most controversial piece was a piece of it that was struck down in United States versus Morrison, the civil rights remedy. And that came out of my experience going to the library. I mean, no one goes to the library to write a law, but a future law professor would, of course. And I did, because there were no women in the Senate, you know. So you heard this on the podcast. There were two women, one Republican, one Democrat. And there were not very many women. There was a staff director, but people are super busy on the Hill. So I went to the library because I'd never studied feminism. You know, I wanted to be a securities lawyer for a while. So I took Ruth Bader Ginsburg and Catherine McKinnon and Robin West, my current colleague, my brilliant colleague, off the shelf. And they taught me that the law was not equal. And I read things that I just sort of, my hair stood on end. I mean, I didn't, at the time, you know, this was controversial. I mean, the New Republic printed something at the time saying that Joe Biden had been bamboozled by a bunch of feminazis, meaning me. Although they also claimed it was Catherine McKinnon who never met with him. But she had an idea about civil rights. It wouldn't have been on the table if she hadn't had her ideas. It was out there floating, but it was a different kind of proposal that we created. Anyway,
So, and
so
so when you formulated the civil rights proposal, how
mhm.
did you conceptualize it? What did you focus on? What drove your vision?
Well, you know, every woman in law school is familiar with the notion of the Bradwell case, where in the Bradwell case, a woman is not allowed to practice law because she can't enter into contracts, and she can't enter into contracts because she's married, right? And that the family is a source of deep inequality for women historically. And so I knew that. And I also knew that there remained on the books things like spousal immunities and things like that. So people were actually, men were immune from tort actions, criminal law actions, because the family was this supposedly safe space. But it wasn't so safe for women. Mm. And so I kept thinking about these things. And then I found a lot of rules that I thought didn't make a lot of sense on the books that treated the crime of sexual assault, then called rape, differently. Marital rape exemptions, for example, more immunities, right? And those immunities have actually been expanding under the model penal code. This is odd. It's called, I call it liberal sexism, but the model penal code decided that sex was a good thing, and therefore if you expanded, if you had a non-traditional relationship, we're going to include that in marriage. So they had something called the voluntary social companion rule, which was the law in Delaware. When I said this to Joe Biden, I think his head exploded because he had a young daughter then. In Delaware, if you went out on a date and you then raped a woman and then cut off her arm, you could not be guilty of aggravated rape because she went out on the date. That was called the voluntary social companion rule. That was supposedly a liberal addition because it wasn't focused on the traditional marital view of the exemption. But it made it much worse for things like date rape. And you've got to understand, at the time, people didn't even think that was real rape. Susan Estrich, a famous professor now at USC, was at Harvard. She wrote a book and she pretty much got run out of town. I mean, because it was really controversial at the time. And those are the things that sort of impelled me. I saw rules that weren't being applied. And, you know, I kept thinking, if this were in the barroom brawl, would the same rule apply? And it didn't. And I explained that to Biden. So when I tried to conceive it, I did something that most people don't think happens, but there's a rule of precedent in Congress as well as in the Supreme Court. And that is, if you've passed it once before, it's likely to pass again. So you use old law to draft new law. Even the most, you know, innovative thing often uses old law. But the problem is something that Reva Siegel, who's a professor at Yale, has noted, that you can preserve through transformation. So I used the 19th century civil rights laws because they originally said that if you act under color of law with a custom, and that these customs were in fact unequal, right? That you could use this as a basis for challenging certain activities. So I used those ideas to form it, and I used the precedent. Now, I know a lot more about the precedent now, and I would not have done that, but because it's much more difficult. But I would have tried to use some kind of precedent at the time. And so, you know, and I've talked about it with lots of people like, you know, scholars of the day. I remember I had privileges and immunities in there, and Cass Sunstein made me take it out. Randy would have loved that. One of our colleagues, Randy Barnett, talks a lot about the privileges and immunities clause. So I read a lot of this stuff literally, you know, because I was teaching myself at the time. I didn't know some of the stuff about the slaughterhouse cases, for example. I didn't know certain things that I now know about the constitutional law undergirding it. But mostly we just thought that the constitutional law was what was on the books. And under the Commerce Clause at the time, we had enormous leeway, right? If the laws were in fact unequal, that's state action, right? And then under the Commerce Clause, it appeared that, of course, you could reach anything that had a substantial effect on commerce under the line of cases dealing with the 1964 Civil Rights Act, which had upheld that law, which ended or attempted to end segregation in the South, legal segregation in the South. And the court had upheld that under the Commerce Clause. And so we used that. The only problem is that the court changed the rules and the court lobbied on this bill, which is a very sad part of this. Not something that I enjoy talking about, but it was also a strange experience to have judges lobby.
And so why were they lobbying against the bill?
Well, they believed they thought it would overwhelm the courts with cases. That's the bottom line. And so one of the judges, the head of the Chief Justices, is an association of Chief Justices of the state courts. So there are 50 Chief Justices of state courts. And they had written a letter to Rehnquist and the committee saying that there were going to be hundreds of thousands of cases, which would swamp the federal courts, basically. And then for the purposes of this legislation, the administrative office actually they came up with their own estimates about how many cases would be brought under it. And they used divorce as their baseline. So they assumed every divorce would involve a certain amount of violence. And that then women would sue based on that in federal court. That was not our assumption, by the way. So they kept issuing all of these statements, and it was sort of like an environmental impact statement where they issued a judicial impact statement. And they also met with me. I remember I was hauled over to, this is an interesting story. Elizabeth Dole was maybe running for president at the time. I don't remember. But she was giving a speech on violence against women at the time. Our hearings were actually changed the dialogue. The hearings themselves were the biggest deal because these women were actually who were willing to talk about it. And this is all before Anita Hill, by the way, but for a year and a half, we had these hearings. And, but anyway, so Elizabeth Dole is giving a speech, and her staffer calls up and says, and this is a day and age that probably doesn't exist anymore, a Republican calling up a Democratic staffer. He says, oh, I need some help on the numbers. Because I was kind of known as a stickler on the numbers because people kept saying we were inflating the numbers. Oh, that can't possibly, you're just inflating that. So I went over there and I walked in, and guess who was there? Bob Dole, the minority leader. And I was like, wow, this is kind of serious. Like, what's Bob Dole doing here? And he had a plate of cookies in his hand. And it was like, he said, here, have a cookie. I said, well, thank you, Senator. And he said, well, why don't you come with me? And this is right around the time when Hillary Clinton had said, I didn't stay home to bake cookies or something. Someone had asked her something about that. So there was a reference there. And I was like, well, no, I don't want to be impolite. Everyone's very polite at this time. The Senate's on, I'll have a cookie. And then he walks, as I'm about to reach for the cookie, he walks with the cookie platter into his huge office where there's a big conference room. It's the conference room to the minority leader's office, which it's a very long table. And at the other end, it's an en banc court. Okay, I had never argued for an en banc court at this time. There are some serious judges there. And so I sit on one end of this very long table, and they think I'm the one who sold Joe Biden on this bill. They think he had nothing to do with it. And I am the crazy feminazi that has actually urged Joe Biden. So I must be this is their image of legislation. Their image of legislation is somehow some staffer, this is Justice Scalia, some heady staffer got it into her heady idea that we should do this. And Joe Biden is just a fool and knows nothing about this, which is completely wrong if you know anything about the former vice president. So I have to impromptu, the cookie disappears. I never get to eat my cookie, and I'm sitting down and I have to defend the constitutionality of the civil rights remedy. And I don't think they knew that I actually had worked as an appellate lawyer for a brief time, for a couple of years. I'd won almost all my cases at the Justice Department. So they then had to they thought they would talk me out of it somehow, and it would disappear, but it didn't work very well.
And then Senator Biden was supportive of the proposal?
Oh, yeah, he's the one who started the whole thing. I mean, basically, when I put that on the list of what we would do, the idea that anyone could bamboozle Joe Biden is, for something like legislation, this is someone who is, reveres the process, who knows the process. And, he got Brady, he got an assault weapon ban, he got Vawa. So he's pretty confident that he can get things done. Mm-hmm. And he had an aneurysm a couple years before that. And my speculation is that he had truly committed himself to be something like Lyndon Johnson, and not in the sense of presidency, but in the sense of getting legislation done.
Mm-hmm.
So we needed to know if we could get this done. And for a while, you know, every proposal that has anything controversial in it, you don't really know. You have to float it. You have to see what people say. And then it's a process of education too. The hearings were all about educating people about a problem that people didn't want to see, because it's ugly. It's ugly. And no one really wants to think that their family can be ripped apart by violence, or someone you purport to love can do something like that. And the stories were pretty horrific. And it was a strange thing to listen to these women, because they gave life to what I saw on the page in the library. So I'll never forget the woman whose husband was the head of the SEC. And, you know, she said, look, I didn't see what he did. You know, he broke my jaw. I didn't see it as a crime. I had to go to the emergency room. I did not see that at the time. And that was deeply disturbing to me. That's when I knew it was going to be, and that's when the hearings were transformative, I believe, for the vice president, former vice president, but they were also transformative for me, because what I saw on the page, right, became life. People were really suffering. It wasn't just the heady staffer, you know, with some brilliant idea. It was real life. So that's what gave me, you know, I kept putting off my job. I eventually got a job at the University of Wisconsin teaching law, something I never thought I could do because I didn't go to Harvard or Yale. And I was delighted at that job, and I was really happy about going out there. But I put it off for not 1, but 2 years, I think, so that I could continue working on the Violence Against Women Act.
So is there, and then we have the decision in Morrison.
Mm-hmm.
Is there any way could a new civil remedy be drafted that would survive this court?
Well, we'll see. The vice president has indicated he would like to see it passed again. And if it has passed once, it's more likely to pass again. I have some hope, and here's what I would do. I would add a jurisdictional predicate. This was not in the original law. A jurisdictional predicate, for those of you who don't know this, is just, you know, for the Commerce Clause, you need something to actually pass in interstate commerce, right? So, or be related to something passing in interstate commerce. But since Vawa was passed, they passed a Hate Crimes Act, and that has that, I would use that same predicate, right? So the federal government can, in fact, prosecute people for hate crimes, but that's only since the mid-2000s, and they used a predicate. Now, I will tell you that, in fact, that there is a dissent out there in one of the circuits, I think the Fourth Circuit, where someone said that under Morrison, it's unconstitutional. But here's why I have hope. They also, one district court, Morrison's legacy is not particularly pretty. And here's one reason why. Not only could you not have a hate crime statute, right? Because Morrison seems to say if it's a crime, if you put that label crime on it, it's separate for Commerce Clause purposes. Now, I think race, which comes after, undoes that, right? Because race, you can say, well, growing marijuana is a crime, right? In a state where it is a crime. However, recently, a district court in Michigan concluded that the female genital mutilation statute was unconstitutional. A doctor was being charged with this. And the reason I have some hope is that Noel Francisco, when Dianne Feinstein got very upset about that, because very few people actually endorse this kind of operation, asked the government, what could you do? And they came back and said, add a jurisdictional predicate. And Noel Francisco, who's the Solicitor General, actually signed the letter to her saying that this would be good enough. I don't think people want to say Congress has no power to stop something like a hate crime, stop something like female genital mutilation. I think also people have seen that it's unworkable for the court to actually carve out crime, because the federalism revolution was supposed to be, and many academics lauded this, they've realized it didn't happen. If it had happened, we would have gotten rid of most of Title 18, which is the criminal code of the federal government, and we haven't. They have managed to find, through jurisdictional predicates, that most of what goes on in Title 18 is fine under the Commerce Clause. And the sad news is that I think that one of the things that spurs this is not commerce, as, Heart of Atlanta, there's something odd about saying that Congress can pass a Civil Rights Act because of a, burger has traveled in interstate commerce rather than because apartheid is anti-American under the Equal Protection Clause. So there's something unsatisfying about the commerce rationale. But I think the jurisdictional predicate could be done. And I think it's worth taking another shot at trying to explain to the court why there is state action. At least a third of the cases that were brought were state actors, and now we're talking about qualified immunity. Why don't state actors get punished for, violations of the 14th Amendment, Fourth Amendment? They also don't get punished for raping suspects in prison or elsewhere. And those were, because there was qualified immunity, people would go to court under Vawa, which had no immunity doctrine associated with it. So
one of the students has written, how should Congress rewrite VAWA so that it might withstand a potential 6 conservative majority? So you think that actually would be doable?
I think it would be doable. I mean, I've drafted one, and I would take the Hate Crimes Act because I don't think that they're going to want to. I think it would be very controversial. Now they may, Justice Scalia signed on to, with his necessary and proper rationale in Gonzalez versus Raich. I don't think the court wants to be in a position where it is telling the Congress that it can't do these things. Because what it had to do was it resurrected the 1883 civil rights cases. I think they can see that, frankly, it wasn't the federalism. It's a little bit like the Garcia case. The dean teaches constitutional law. So they tried to have fundamental state, function, a test that O'Connor created, and it didn't work. Their test on crime didn't work either unless they were going to really take it to its limit and then get rid of Title 18. They weren't willing to do that because it would be controversial politically, in my view. It would be very controversial. This is why Noel Francisco, it would be very controversial for this president to say, oh no, I think that's really great because he's, in my perspective, he's an anti-woman president, but that's my perspective.
So one of the students asks, are there things the Democrats could do to bring the Republicans onto a new VAWA bill without compromising the integrity of the legislation? So it sounds like you think that actually a bill, Republicans might sign on to something that's full force and does what has to be done.
They might. I mean, there are going to be people like Mike Lee who and the Federalist Society true believers who don't like jurisdictional predicates. But here's the problem. The rationale, if VAWA's not good enough, the Hate Crimes Act isn't good enough. And I'm not so sure they want to tell their constituents that you can't have a gay bashing crime and you can't have a Jew bashing crime and Congress has no power to regulate that. I personally believe that the best thing they should realize is something that Vicki Jackson, I learned from her, who formerly taught at Georgetown and is now at Harvard, which is that I read the 14th Amendment as an amendment of the entire Constitution, not just of the Commerce Clause. And I think you could reconcile Heart of Atlanta, which is the case involving the 1964 Civil Rights Act, and say Congress has more power when commerce is infected with discrimination. And young women think that sexual harassment, sexual assault, et cetera, is infecting commerce, their opportunities at school and work, et cetera. So that, forget about general criminal law, but when you have a commerce that's infected by a discrimination, there's a different rule, okay? So the 14th Amendment, Section 5, gives you more power under the two together rather than you have separately. And that would reconcile Heart of Atlanta. It would squelch the court, the court has tried to push back on using the 14th Amendment in many ways, and it would be consistent with that. But it would be new for them.
But it seems like that would be a better way to get the Heart of Atlanta result than the way the court actually decided it.
Yeah.
And it's not really about commerce per se, right?
Right. It's not about commerce per se, but it's hard to say it doesn't have. I mean, when I tell students that, it doesn't have an effect on, they thought it didn't have an effect on Congress, I get a lot of pushback from that. There's some sense in which, of course, if I'm, traumatized by certain physical activities, so I can't go to school, I can't. Brancala, who is the woman in the case, she quit school, right?
Right.
So they do see it as affecting their ability to make a living, right? And certainly after the Me Too movement, given the high-end situation of Hollywood, they certainly believe that that affected their ability to make a living. So there are more examples of that. So I think it's going to be a harder, it'll also be harder if Congress passes it again, because this happened with the Family and Medical Leave Act. Justice Rehnquist was not exactly, he voted all against women's equal rights laws, but he wrote the opinions saying they could pass the Family and Medical Leave Act. And he did that because Congress had tried before other things and they had failed. And he basically gave it more of a pass because Congress had tried the Pregnancy Discrimination Act that still hadn't, ended the problem. So if Congress actually passes this again, there is precedent for saying that that Congress should be given more deference than they gave in the first Morrison case, right? Because it's a different kind of Congress, et cetera. Now, that doesn't mean it would be easy. It would take a lot of work. But I think it's possible. I think it's certainly worth arguing.
And so is your Stanford article really kind of at its core response to Morrison?
I think it is, in part. I gave you two very different things because I like posing puzzles for my students, and students love podcasts. And it's really a puzzle. Why is this woman sort of who sounds like a, equal rights person ending up writing about the structure of the Constitution? Well, we did a civil war. We had a civil war because of the structure of the Constitution, what it meant, right? The relationship of the states to the feds. That's why we get the 14th Amendment. And the lesson of constitutional history is that the states have often refused to give equal rights to people. What do we know from the segregation of the South? The states have not been the leaders in this realm. The feds have always had to nudge and push and prod the states. So, I think it's in part a response. It's also an independent theory about the Constitution. It rests on a different theory of the Constitution, in my view. I've always been interested in structure. I don't do a lot of rights claims because I've always thought that the structure mattered more. I know that people often find that, I don't know about that. But, if you don't have courts, if you don't have legislatures, you can't get a protection for a right. So you have to have the basic institutions. And I've always thought about that since my experience in Congress as a lawyer, working for Congress, because I understood the power of the Congress and I didn't denigrate it, as many people do, as being full of politics. Politics is a strange word. I wish we had more words for things that were more articulate, because it can mean partisanship, which is sort of empty ideology, unthinking ideology, and it can mean democracy, self-governance. Two radically opposed ideas in one word, politics. But I thought a lot about that before I created the whole idea, or I thought of talking about constitutional structure in terms of electoral relationships. Obviously, it wasn't, the Electoral Connection is not my idea, that's David Mayhew's, but what I did was I turned that into a measure or a thought process for evaluating separation of powers claims that did not depend upon adjectives. What I mean by that is executive, judicial, legislative. These are the adjectives that the current court believes actually create pigeonholes in which we have to put activities. And it doesn't work. It doesn't actually describe the Constitution. The president's powers are included in Article 1. The veto power is pretty important, right? It's in Article 1, not Article 2. The Constitution doesn't hermetically seal the departments. If it did, they couldn't check each other. So, my experience taught me that, but also rereading the Federalist Papers. Yeah, I'm the only feminist who, on the train to Delaware, took up the Federalist Papers. I think if Biden had looked at that, I don't know what he would have thought. But anyway, I think if you're going to deal with hard problems, you want to go to the core. If you study science at all, you got to get down to the brass tacks. So I started there and I thought a lot about it. And I thought, well, this actually would explain something real in the world that would shift, like constituency relationships. That would actually mean something in the real world, as opposed to being about these adjectives that cover all sorts of things. So for example, we have the Capitol Police, they execute, right? The adjectives are not going to help us and they're going to get us into trouble. And I predicted this. And guess what? We have the unitary executive. My colleague Howard Shalansky says, my head explodes when you mention John Yoo, but that's because he's a professor at Berkeley who decided that we could torture contrary to what Congress said and John McCain said because of the unitary executive. The problem with the unitary executive means all sorts of things. It can be something banal, like the structure of an agency, which I think is what Justice Kavanaugh seems to think, or it can mean the executive can do anything he wants. And that is clearly not what the Constitution says, in my view. So, I started doing this, and one of the things that gives me confidence in talking about it is the combination of studying very hard, being the nerd, right? So I know when Justice Scalia says the impetuous vortex of the legislature, that he's misquoting the Federalist. I know that, right? At the same time, I've experienced being in the Congress. So I understand how those motives, which other people just denigrate as politics, are really about representation. And Vicki Jackson and I have talked about this a lot, that representation is really the word we want here. Because what you may think of as politics, they may think of as something that they need to represent the public who elected them. So marrying those two has given me a certain amount of confidence to do something that I think I was never taught to do, I was never groomed to do, and was pretty outrageous that I did it. I remember when I was visiting at Yale, it's very hard to visit at Yale without having gone, actually been a student at Yale. But anyway, I sort of took it as a flyer. So I said, no one's ever going to give me a job here, so I'm going to give a paper on the separation of powers. So I did. It was pretty fun. Akil Omar asked me a question that was timed at 9.5 minutes.
Oh my
His
gosh.
question was 9.5 minutes. And I love Professor Omar. He's terrific. But it really engaged them. He was really interested. Okay.
So let me, one question that we're almost out of time, but one question that a number of people have asked, because it's on everybody's mind. Under your approach, what do you think about court packing?
Well, it's on everyone's mind, but I think it's a little premature, to tell you the truth. I thought that FDR, in the Skinner book, it was a 500-page manuscript that Norton made down to something extremely readable, which is great, but I had a whole chapter on court packing in there that hasn't been published. I think FDR's proposal was unconstitutional because it gave him too much power to pick the particular people. I think it's premature because we don't know what the Senate will look like. And I don't think that there are plenty of things that the Congress can do to make the justices' lives not what they want them to be. I wouldn't recommend that necessarily either, but I would want to see what was going on in the Senate because it's very volatile now. I'm told, and I could be wrong, I'm not a political scientist, that there are at least 8 seats that are potentially up for grabs in places that most people have not been following, like Kansas. So I would really wait to decide that. I think it's an extreme measure, personally, and I'm on record as saying that FDR was, I think he regretted it. Homer Cummings was not a truly brilliant man. Homer Cummings was the Attorney General who drafted it for him. So I'm given how it didn't work out before, and here's why, because you'll get some opposition from your own party, and that's what happened to FDR, because it seems like a big deal. Now, the truth is the court there is no number in the Constitution. It's gone bigger and, Grant did it. I don't know, other people did it. I think there are other things you can do. I'd like, to see the administration, maybe question some of the interpretive principles that came out of the original Office of Legal Policy and Office of Legal Counsel. They can certainly reverse the Meese memo that led to the degradation of legislative history. They can write their own memo if they want about how to interpret statutes and the Constitution. Congress can do various things. So I think it's something we need to wait and see about. And I also think it's something that Republicans want liberals to be talking about, because they want to get people scared about Joe Biden. And so I don't think we're thinking about it straight. I do believe there are times that are called pure politics, and this is one of them. And this is not the time to really be thinking about it people aren't going to be thinking about it in a rational way. So let's wait till after the election, and then we can try to see. what's gonna, but history suggests it's not a really good, you know, way to go.
It didn't work out very well for FDR.
No, it did not. It did not.
So what could President Biden do to achieve the kind of court rulings that, would validate, what he thinks the Constitution should mean?
Well, I think it's less about the Constitution. I mean, the problem that I've identified is prior to the Constitution. So it has to do with statutes. I mean, look at the biggest cases up there. The Healthcare Act has been up there twice on statutory readings that are not about the Constitution. Okay. So I would worry about that in some ways more, because he's going to wants to pass a lot of statutes. So he can respond to that in the statute, and so can Congress. They can create their own rules, in my opinion, for how to interpret it, and they can write them in. They're called rules of construction. They can be savvy about the text. They can try not to make the typo mistake. They got the second case up there. So, I do think that they can do things in crafting legislation and executive orders that responds to the court. Ultimately on constitutional issues, they can try to persuade them, in their own terms. There are lots of historical arguments. I mean, some people think that the Hiller, for example, use originalism. You're an originalist, Dean Treanor. There are lots of historical arguments about the extent to which guns were actually regulated at the founding, right? So I guess perhaps the Biden administration will have to hire some historians. I don't know.
I think that's a great idea. What would you think about making all federal judicial, this is a student question, making all federal judicial appointments require 60 votes instead of a simple majority?
Well, thank you for that question, because I have never, because of my own personal experience, it's not easy. My kids were threatened. It was not a pretty picture when I was nominated. And so I have never spoken out against judges until they got away with, they got rid of the 60 vote threshold. So before the current, and this is why I view this getting rid of that threshold as an attack on the court, to tell you the truth. I don't think this makes the Chief Justice happy personally. And he and I wouldn't agree on a lot of stuff, I suppose, but I don't think he's very happy right now. And I wouldn't be happy if I were in his situation, because it is an attack on the court. You've changed the rules. So the rules were that, Ruth Bader Ginsburg had over 90 votes, I think, right? Right. This may be decided by the Vice President of the United States. 51-50. So this is not good for the court as an institution, in my view. The problem is, if you have people who are not bipartisan, and then you add bipartisan folks, the court is still going to be, not in your perhaps median zone. So game theorists would say, oh, you've got to have tit for tat. So you've got to put on extremists. I personally prefer the 60 vote rule, because at very least you have to appeal to some moderate coalition. I was confident that I could get 60 votes, by the way. And why couldn't I get a hearing? Well, one senator retroactively blue slipped me, but we don't have the blue slip anymore. It's just technical. You don't need to know that. Yeah, I think it would be much better to have and many countries now have a 2/3 rule for confirming appointments. And I think that would be a much better rule, frankly.
Well, this has really been an extraordinary conversation. I always close with one final question from the students, which is kind of a big picture question, but I do want to say this has been amazing, and I just want to express my gratitude to you. So this is our final question. Bringing this full circle, thinking back to that young woman reading her law books near Fraternity Row at Berkeley, who we mentioned in the podcast, based on everything you've done in your very accomplished career thus far, if you could give advice to that young woman, personal or professional, what would you say to her?
Well, I'd tell her to be a little bit more confident in her skills much early in life. She'll experience a lot of disappointments, but also amazing opportunities. And to misquote Ruth Bader Ginsburg, who I miss so much, only in America could this possibly happen.
That's a wonderful way to end. So thank you, Professor Nourse. This was
Thank you, Bill.
illuminating and inspiring. Thank you.
Bye, guys.
Take care, everyone. See you next week.
Take care. Bye.